Are you able to explain why some of your workers are classified as independent contractors while others are classified as employees? Is it based on your contract with them? Is it just vibes? Or do you know the rules? If you're operating off of just the contract or the vibes, that may put you in a scary position. Misclassifying a worker can mean back wages, liability for unpaid taxes, and can leave you subject to penalties. The federal government is in the middle of rewriting the rules on worker classification. Well, not exactly rewriting. This administration is signaling a move back towards a less stringent standard. But until that rule is final, the current standard is what applies. Today, we're breaking down what the law actually looks like, where things stand right now, and what you should be doing regardless of what rule is enforced. I'm Jasmin Hurley. Welcome to Main Street Counsel. First, let's get to the so what. What does this even matter to you as a business owner? When someone is classified as an employee, the business is responsible for a whole set of obligations: payroll taxes, unemployment insurance, workers' compensation coverage, and in some cases, benefits. The employee also has legal protections, minimum wage, overtime, anti-discrimination protections, and more. There are also intellectual property protections that you as the employer enjoy. When someone is classified as an independent contractor, those obligations largely disappear. The contractor is responsible for their own taxes. There usually are no benefits. Fewer worker protections apply, and ownership of intellectual property is negotiated. Those differences are significant for both parties. Naturally, there's an incentive to classify workers as contractors when they might actually be employees. To prevent this issue, federal law has drawn a line between the two. But one of the issues is that line has moved a little bit over the last few years. So here's a quick history of where we've been, because it helps explain why things may feel a little uncertain now. During the first Trump administration, the Department of Labor adopted a more business-friendly standard for worker classification. It was a two-factor test that focused primarily on two things: how much control the business has over the worker, and how much opportunity the worker has to make money or lose money based on their own decisions. Under that approach, it was generally easier for businesses to classify workers as independent contractors. The standard was less stringent, and there was more flexibility on how the analysis was applied. Now, in 2024, the Biden administration replaced that rule. The new rule reinstated what's called the economic reality test, a six-factor analysis that courts and the Department of Labor had used for decades before 2021. That core question under the test is whether the worker is, as a matter of economic reality, dependent on your business for work, or whether they're truly in business for themselves. Those particular six factors, the worker's opportunity for profit and loss based off of their own decisions, how the worker and the business each invest in the work, degree of permanence of the relationship, the nature and degree of control of the business over the worker, how integral the work is to the business, and the worker's skill and initiative are critical. But no single factor controls the analysis. No factor is automatically more important to the other. It's a totality of the relationship. And under that standard, it was a little less easy to classify workers as independent contractors. So where are we now? In early 2026, the second Trump administration signaled that they wanted to reinstate their previous rule. The comment period on potential changes to that rule closed April 28, 2026. So the current administration formally gathered public input on whether and how to change that classification standard. Now, the final rule has not been released, but signals from this administration point toward reverting to that first Trump-era standard, the less stringent two-factor test. And what does that mean for you? Well, we are in a period of genuine uncertainty. The rule that was on the books may change. If it reverts, some arrangements that looked risky under the economic realities test might look more defensible. But we just don't know yet. And we all know, I don't know is never a great place to base your business decisions, right? So let's walk through those six factors, because regardless of which direction the rule goes, understanding what the current test looks like will give you a baseline for evaluating your own working relationships right now. Here's something important to keep in mind as we go through these. Again, no single factor controls the outcome. It is a totality of the circumstances. That's a fun word, right? The test looks at the full picture of that working relationship. So factor 1, opportunity for profit or loss based on managerial skill. Can this worker make more money or lose money based on their business decisions? And not just based on how much they work, it's based on decisions that they make about how to run their own work. A truly independent contractor might choose to hire help, negotiate rates, take on more clients, take on different clients, and invest in better tools. And those decisions affect their earnings. If the person's income is essentially fixed to what you pay them and there's no real upside or downside to their choices, that weighs more towards employee. Factor 2, investments by the worker in business. This factor looks at whether the worker is making real investments in their own business independent of you. A contractor who owns their own equipment, maintains their own workspace, invests in tools and training that serve multiple clients is demonstrating genuine business independence. If everything they use to do the work belongs to you or was provided by you, that weighs towards employee. Factor 3, degree of permanence of the working relationship. Is this relationship ongoing and indefinite, or is it tied to a specific project with a definite end? Contractors are typically brought in for specific time-limited work. If your contractor has been showing up every week for 2 years with no defined end date, then it might look like employment. Factor 4, nature and degree of control. How much control does your business have over how the work gets done and over the worker's ability to work for others? This isn't just about setting the hours or requiring a uniform. It includes things like whether you supervise the work closely, whether you set the rates, whether you restrict the person from working with competitors, and whether you control the economic terms of the relationship. The more control you have, the more it might look like employment. Factor 5, extent to which the work is integral to the business. Is this work central to what your business actually does? So for example, if you're running a landscaping company and you bring on a landscaper as a contractor, that work is core to your business, which may weigh towards employee. If you hire someone to redesign your website or do your marketing, that's a discrete project outside your core service, which may weigh differently. The more essential the work is to your everyday business operations, the more this factor may point towards employment. Factor 6, skill and initiative. Does this worker bring specialized skill to the work, or are they using that skill in an independent way as someone who might run their own business? This isn't just about whether the work requires expertise, it's about whether the worker exercises their independent judgment and initiative, markets their own services, and applies their skill in a way that reflects genuine business independence. Someone who's skilled but simply follows your direction isn't really exercising the kind of initiative this factor is looking for. So let's talk about one thing, the contract label. Calling someone a contractor in your agreement or having them sign a contractor agreement does not make them a contractor in the eyes of the law automatically. Courts and regulators will look at the actual substance of the working relationship across the economic reality factors. The label matters less than what's really happening. I have seen businesses get burned. Perfectly worded contractor agreement doesn't protect you when the day-to-day reality of the relationship looks different. So what's the actual risk if you misclassify a worker? Well, there's a lot. On the federal side, the Department of Labor can require you to pay back wages. And that's the difference between what you paid and what the worker would have received as an employee, including overtime if that's accessible. The IRS can assess back taxes for payroll taxes that should have been withheld. And then there are several penalties on top of that. On the state side, if your state's like Ohio, it has its own worker classification rules. They may apply to things like unemployment compensation and workers' compensation coverage. Misclassification in those areas carry their own set of penalties and consequences. And of course, this isn't theoretical. Worker classification audits happen all the time. Usually, it's triggered by a former worker filing for unemployment, or they do something wrong and they want to sue you. It could be a competitor who thinks you're skirting the rules. It could just also be a random audit, and the exposure can go back for years. What you can do right now, and what I recommend for everyone who owns a business, if you are using contractors, do an audit of your working relationships. Go through every worker you have who is not on payroll. For each one, ask, how much control do you actually have over how they work? Do they have other clients? Do they have their own businesses? Could they realistically make or lose money based on your own decisions, separate from what you make? Look at your agreements. Your contract agreement should reflect that actual nature of the relationship, not just use the word contractor, right? If the agreement says contractor, but the relationship looks more like employment, then that agreement is not helping you. Third, document any independence that there is. If someone is a true contractor, make sure that's reflected in practice. They should be setting their schedule, using their own tools, invoicing you on their own terms. The more documented independence you have, the better position you may be in. The DOL rule is, of course, not final, but it'll probably be made final soon. When it is, I'll definitely be providing you an update. So make sure you do the thing, like, subscribe, ring the bell, so you'll be updated on any new videos that we post. And if this video raised questions about your own business, please reach out. This is Main Street Counsel. I'll see you next week.